A tremendous sense of disappointment is what's coming in from the NAS Foundation, one of the trailblazers and one of the power players when it comes to fighting for LGBTQ rights. Now let's get to our guests. I'm joined by Ashish Dikshit as well as Ashutosh Srivastav, who are joining us on the broadcast. Ashish Dikshit, I'll come to you first. What the Supreme Court has put out when it comes to LGBTQ rights and the progress towards it, this kind of framework that they've put out. In your opinion, is this the best the top court could have done? Mr. Dikshit, can you hear me?
Yes, I can hear you. Am I patched in? I'm not able to see the news feed.
Right, we'll try to reconnect with you. Ashutosh Srivastav, that same question for you. What the Supreme Court has been able to lay out as kind of, if you can say, a kind of guidelines for LGBTQ empowerment, is this the best the top court could have done?
Yes, this is what I think, because see, the central government had very much clarified that this is something the same-sex marriage should be referred to the parliament, and India being the largest democratic country, let that democracy be protected and the sentiments of people to be properly represented before the parliament, because there would be people who would be wanting and there will be people who would not be wanting it to happen, considering a lot of other social aspects. So I think the Supreme Court or any court for that matter is not there to make a new law, but to interpret the existing laws. And accordingly, the petitions which were filed, basically they were, about to, how to interpret the Special Marriage Act, which was formed in 1954. And in the Special Marriage Act, the different religions and different castes, how their marriages have to be performed or solemnized, that is what mentioned. And even some of the citizens who don't follow any religion, even how their marriage has to be solemnized, that is what is mentioned. Now, there is no mention about same-sex marriage in Special Marriage Act. And this is what Supreme Court could interpret, that we cannot change the law, we can only make interpretations. But yes, I do agree that the Supreme Court has, rightly, addressed the issues faced by this same-sex, couples, and accordingly has given directions to the central government, to the state government, and to the union territories that there has to be protection of law to all these kind of couples who are being unnecessarily targeted. Many a times the complaints are being filed by the families and they are, unnecessarily dragged to the police station. They are unnecessarily harassed. And there are a lot of issues related to violence on them. So they should also be treated equally like any other citizen. And the Supreme Court has also clarified, about Article 15 of the Constitution, which says that none of the citizens of this country should be discriminated only on the basis of caste, religion, or sex. And accordingly, every citizen, whether, irrespective of their sexual orientation, should not be subjected to such kind of cruelty, and they should be given certain protection. So far as the practical issues of this couple are concerned, like opening a joint bank account, or maybe passport, ration card, or maybe so many such other documentations, for which the court has referred again to the formation of a committee which will find out all the relevant issues being faced by LGBTQ and should be addressed in a proper manner, and accordingly a new rule or law can be framed which will protect this particular category, and it should give all the respect and dignity to them to stay in the society. So I think this is the best it could have been done, and now it is the parliament which will further decide on this course of action, considering the sentiments and the wish of the people at large, being India being the democratic country.
Right,
so
but
I think Yes, yes.
Right, but Mr. Srivastav, I remember during the triple talaq debate, former Law Minister Ravi Shankar Prasad said that, the Muslim women of India can't go around showing a Supreme Court verdict when it comes to getting protections from things like triple talaq. Now, at the end of the day, while the Supreme Court has made it clear that adoption rights can't be given, there is no fundamental right to marry, it has given these kind of guidelines to the center and the states when it comes to empowering the LGBTQ community and giving them some level of legal protection. What practical impact do you see this on the ground when it comes to law and order and other kind of civil laws?
Obviously, the aim of the Supreme Court is to have the protection of law and maintain the law and order so far as this community is concerned. And accordingly, the court wants certain directions, as it has also referred to certain judgments like Lalita Kumari judgment, etc., wherein the police should make certain inquiry before registering any such FIR and unnecessarily harass this kind of people and bring them to the the police stations time and again. So if they have their wish, if they stay together by their choice, nobody can stop them. And we know that in 2018, this section 377 of IPC was already partially amended for the protection. So in a way, the Supreme Court has also recognized the relationship between the same sex. However, the marriage is concerned, it is not at all defined in any of our existing laws, and we know that it will not frame a new law, but it can make interpretation, and it can just clarify the existing laws. And accordingly, it has given this task to the Parliament only, and it has not encroached upon the rights of the Parliament, where the the MPs are elected by votes by the people, and they represent the people of this country, and accordingly they can make the rules, regulations, or the laws. And these laws which were made earlier were also made after a lot of discussions and after following the due process of rules and regulations as prescribed by the Constitution. And making any such drastic amendment in any of the law will be very difficult proposition for the Supreme Court as well. So I think it is a very new issue which should be discussed in the Parliament. That is very much correctly interpreted by the Supreme Court as well. And so far as you mentioned about the law and order situation, I think yes, the law and order situation will now improve rather, because when we are treating everyone equally, at least being citizen of this country, that is what is required, and everybody should be given the dignity and the respect to live in the society without being carried away with such kind of a stigma. So that is one part of it which Supreme Court has very well dealt with. Now, other part, the marriage part of it, obviously that lies with the Parliament. So I think it is a very balanced judgment by which the Supreme Court has also protected our legislature, which has been framed as per our existing constitution, and it has not interfered with the the constitutional provision so far as the Parliament is concerned. And at the same time, it has done its best possible to protect the community from being unnecessarily subjected to any sort of cruelty or any sort of unlawful acts on them. So it is a very balanced judgment according to me.
Right. So at the same time, we're also joined by Ashwini Dubey on the broadcast. Thank you, Mr. Dubey, for joining us on CNN News 18 as this kind of legal debate takes shape around same-sex, on the rights of same-sex couples. Looking at what the Supreme Court has put out when it comes to these guidelines to give protections to the LGBTQ community, I want to reiterate the same question, because many LGBTQ activists are saying that while they can't depend upon the legislature, given the views of a majority of politicians, they depend upon the courts. But what the Supreme Court has put out, is this the best that they could have done?
Yes, the Honorable CJI in its directions have categorically, the center as well as to state have said that these queer community people should not be harassed, and if any complaint is filed before the police has to take action, and police will also not call it. And the second, you would agree to one point where all the judges have agreed with the point contention made by the argument made by the Solicitor General when argument was taking place, that they will refer this matter to the committee, and committee headed by the Cabinet Secretary will look into all these aspects in the wisdom, where they will see that where marriage between a biological man, biological woman takes place if under the personal laws, codified laws, and whether this marriage can be identified, can be recognized under the Special Marriage Act, or there has to be a separate law which is to be formed. Because as of now, if we see, you see there are Hindu Marriage Act, Christian Marriage Act, Parsi Marriage Act, Divorce Act, and Special Marriage Act, and the Foreign Marriage Act. They only recognize the union of man and women. There is no special provision which says per se that the people who are not the man or woman from the LGBT community can form can become the husband and wife. And the second, this so far as the statutory right is concerned, because the court have categorically said that there is no fundamental right to get married and the constitution does not recognize it. But so far as the giving rights are concerned, that very rightly the court have, all the judges have agreed to it, that they should be given right, whatever right can be given. But so far as the statutory, because there are statutory rights which says that the marriage can between the biological men and biological men can happen. And third, there are more than 160 laws which only deals with man and women. How those laws should be overruled, how the particular section shall be quashed, that only will depend on the wisdom of the parliamentarians and the society, the practices which exist in this country, and how the world has reached there. For that, there is a committee will be formed, and a committee will look into all these aspects. But at the last, you would agree that all the judges have agreed that they should not be harassed. So far as the living in a dignified manner, as has been said in Naute's judgment, they should live in a dignified life, and right to live in but dignity is their fundamental right. Because if you remember the Supreme Court's ruling which granted same-sex couples the freedom to lead a dignified private life, that ruling is here. Many judgments have been considered, but ultimately it is on the wisdom of the parliament, and let's see what the cabinet secretary's report and under committee headed by him comes to the conclusion. But ultimately it cannot be said the Supreme Court has categorically denied it. Supreme Court has already enhanced the right which was given to the LGBTQ community in past.
Right, but what you're pointing out is something that, we were also discussing when 377 was decriminalized, and when the Supreme Court also made that historic ruling on 377, that the right to dignity is something that has been given by the court. But how far have we moved on since then is the big question. Sumit Chander, do you think that this Supreme Court verdict has taken us a step ahead when it comes to empowering the LGBTQ community, or are we still where we are after the decriminalization of 377?
Definitely there is a step ahead, and when we talk about what is that step which has now gone forward, and it gone forward to a great extent when it has clearly now defined and the rights provided under Article 14 and 15 of the Constitution. Article 14 of the Constitution, which clearly says that equality and there should be equal protection of laws, and Article 15 again now clarifies that India, it forbids any discriminations on the grounds of gender. Supreme Court has now upheld that constitution, which is what the Supreme Court was required to do. The expectation that marriages should be allowed. I'm sorry, there is some disturbance coming.
Right, please go ahead. Please go ahead.
Yes, so definitely what was the expectation was that a gay marriage or a transgender marriage should be allowed. Supreme Court has clearly held that they are not going into the domain of policy making. So very rightly so, but wherever it can, given the rights given under this judgment today, which is historical in its own frame, those rights have been clearly given. Rights which otherwise was not available to transgenders, such as adoption rights, such as rights of giving a nomination, so far as your pension rights are concerned, various other rights otherwise which was not available, for which Supreme Court clearly said that where, say, the transsexual marriages have the right to get married and do an adoption, if the transgenders don't have that right, then by all means that right now will be given under the system. So there is a very big step forward. Committees, however, has been made, and the Supreme Court has directed that the committees be made by the state and the central government to now further implement. But the guidelines have now been given by the Supreme Court. and the direction is now clear as to what the government is now going to look into and implement for the future.
Right. Vijayanti Mogli is also with us on the broadcast. So, how do you see this entire stand from the Supreme Court to put this in the ambit of the elected officials? Because given the opinions elected officials have had about same-sex marriage and LGBTQ rights, because I've heard health ministers, many health ministers in the past who have called it a Western disease. But given the fact that the Supreme Court has come out with these guidelines and has put this in the onus of elected officials, the formation of a committee, do you think that this committee will be spurred to take action, or will they just drag their feet?
I'm sorry, is the question put to me?
Yeah. To Ms. Mogli, please. Go ahead.
So
Sorry.
Go ahead. Ms. Mogli, please go ahead.
We don't know. We can't predict yet. We will only be hopeful that the high-powered committee headed by the cabinet secretary shall not only hear powers that be at the federal level, the state governments, but also voices and representatives from communities from all parts of India, from all states and union territories, that we will be hopeful that it won't be just a bunch of babus and IAS officers, a boys' club that comes together to decide on somebody else's rights. Nothing about us without us. This is the jurisprudence from the disability rights movement. Nothing about us without us. So as transgender persons, we are striving hard to become IAS officers. Many of us have written civil services examinations. We have quite a few lawyers already. We are working very, very hard to find our place of dignity in society as lawyers, as civil servants, as private sector employees, and so on. So we will only be hopeful, only time shall reveal. And it's our responsibility now as community members not to only go to courts, but to also painstakingly, even if doors are shut on our faces, which has happened in the past, people have spat at us, people have called us names, used the worst of expletives and invectives and unparliamentary language at us. But it's very important that we wipe all that away and go back there with a smile if possible. I don't want to burden anybody, and continue the advocacy. Great historic changes don't come on a platter. We will have to put in our best time and again in the face of failures, as was the case with the women's rights movement, with the disability rights movement, and so many, very many other movements. I think this is a small step ahead. I don't think it was what we wanted it to be. Many of our friends wanted it to be. But out of as I said, we will rise of our own ashes. Like Phoenix, we shall rise. Nothing can stop. It's only a comma. It is only a comma, not a full stop.
Right. So the only hope is that this committee kind of puts a pep in their step when it comes to pushing forward LGBTQ empowerment. Sumit Chander, when it comes to that committee that has been, directed by the Supreme Court to look into LGBTQ rights and look at the entire ambit of these rights, what is the pressure on this committee, especially because the order has come from the Supreme Court, to act in an expeditious manner? Sumit Chander, can you hear me?
Yes.
Yeah, please go ahead. That question was for you. Yeah.
Yes. So these committees which have been formed, these committees the guidelines have been given. Supreme Court has given its views very clearly as to what is expected for these committees to be done. Now, these committees are to be formed. Of course, it will take its time, but it has to be now done in the manner and under the guidelines now given by the Supreme Court. Supreme Court has also decided and who are going to be the members of the committee. And these guidelines now, each government, the state government will also bring these committees, the center and the state government, and these committees will now put into frame the guidelines now given by the Supreme Court. The protection, for example, the common number, the helpline number specially made for issues, more particularly with all the pure union, as they call it. So now these numbers, the committee has to decide as to how to implement these laws and give them the protection as to enable the proper effect of the Supreme Court judgment.
Right. Thank you, Mr. Chandra, for sharing your perspective. Ashwini Dubey, I have a couple of more questions for you when it comes to understanding the kind of legal modalities surrounding this entire Supreme Court verdict. No fundamental right to marry is one thing that the Supreme Court has laid out while looking at the LGBTQ community. But this statement coming in from the Supreme Court, do you see wider social legal ramifications coming from such a statement?
You see, look, so far as the no fundamental right of getting married by the LGBTQ community is concerned, means that there is already a statutory law. And statutory law does not recognize the marriage between the queer community, between the same-sex couple. And that is why the Parliament, the Supreme Court judges, you would agree that all the judges have agreed that let's Parliament decide it. It is within the domain of the state to frame the law. And that is what the judgment delivered by Honorable Justice Bhatt and Honorable Justice Narasimha and Honorable Justice Kohli, they have categorically said so far as right are concerned, certain rights can be given. But so far as the recognition of marriage is concerned, that cannot be given by the court, because this is completely lies on the domain of the Parliament, because there are various laws existing in the country. Like how? You see, the registration of marriage of same-sex persons results in violation of existing personal laws, because there are two kinds of laws. One laws derived from religious scripture, other laws derived from the codified laws. So codified laws probably like degree of prohibited relationship. There are certain degrees of prohibited relationship in the Special Marriage Act also, in the Hindu Marriage Act also. Conditions of marriage, the ceremonial and ritual requirements under personal laws governing the individuals. And if marriage is to be solemnized and registered under any personal law, what is the requirement of registration? If marriage is to be registered under the Special Marriage Act, then how restitution of conjugal rights will dealt with? What would be the modalities for judicial separation? What would be the modalities for divorce? What would be the conditions of divorce? What would be the alimony and maintenance? What would be the permanent alimony? If there is dispute tomorrow arises, how it will be dealt with? How the property will be disposed of? How adoption will be dealt with? How guardianship will be dealt with? So that is Supreme Court said, that the Parliament has designed and framed the marriage laws in the country, which are governed by the personal laws, codified laws, relatable to the customs of various religious communities. And now it is not that the door has been shut. Door to the justice is still open, because committee ultimately either today or tomorrow has to submit its report. If committee says no, legal recognition cannot be given, then they have to justify why legal recognition cannot be given. If legal recognition is to be given, then what laws is to be framed, what rights they would be having, because you have to see not only the Indian context but the world context also, because various countries have also given rights. So it is not that the justice has come to an end. Justice has still open, door to the justice is open, because today or tomorrow, if the cabinet secretary's report of the cabinet secretary comes, then ultimately that will give again rise to raise this question to the court, because court has said that look, the Solicitor General and the Centre made a submission to the court that we will look into it, refer this matter to the committee, and committee ultimately is amenable to the Constitution, and if there is any violation of any individual, that has to be looked into by the court. So I think that still there is a hope, and ultimately, as rightly said, that nothing comes free. They have to fight for it. They have reached here from decriminalizing 377. Now they have reached a certain rights have been given. Let's see how the Parliament decides it, how the 160 or more laws has to be changed. That is also one of the question. Yes.
Absolutely. Thank you, Mr. Dubey, for sharing your perspective as the legal debate only continues after the Supreme Court verdict, because we're getting a lot of reactions coming in from many LGBTQ activists who are saying that if we depended upon committees to decriminalize 377, that would not have happened. They depended on the legal system. But in this case, of course, now the onus is on the lawmakers to kind of frame those laws to empower the LGBTQ community beyond the decriminalization of 377. We'll continue to track all the developments which are coming in as this legal political debate continues. For now, a quick break. More news and updates on the other side.